15 seconds after our appointed start time. So let's get started. Our folks online will be fairly punctual. Appreciate all of you folks coming here today. We have a series of CLEs like this designed to help folks that may be new to some areas of practice. And we're delighted this morning to have you folks all here, actually, I suppose technically this afternoon at this point. But delighted to have you here in person, and there are about 60 people who are registered online. So we will be recording this at the same time, and we may have some questions that come in through the little chat window. We will not have the distraction of noise over the speakers, just because it makes for a lag in the sound. But we'll handle those mechanics later. We're especially happy to have Jill Sauber with us today to present this topic. Jill's been an enthusiastic volunteer for the Bar Association, is the chair of the Law Governing Council now?
No.
On the Governing Council?
Yeah, I'm on.
Okay. And volunteers for us quite often with the Wills for Heroes program that the MSBA has been running for now about 10 years, I think, which provides basic wills for first responders throughout the state. Jill herself graduated in 2013 and currently works at Chestnut Cambronne. She focuses in the area of elder law and emphasizes estate planning and administration, hence today's topic, which she's more than well qualified to speak on. Her JD was from the University of St. Thomas Law School, and we appreciate very much her being willing to come and share her expertise with us this morning. Jill?
Good afternoon, everybody. So I'm going to try not to spell this. I'm kind of a putt sometimes. So what Mike didn't tell you is I'm also a licensed mortician. And the reason I mention that is I love this stuff. And I could talk all day about probate, elder law. I won't bore you with all of that. I'm kind of going to give more of a broad overview of probate. We're going to go through the basic steps to file for an informal probate. I'll jump back into how to file for a formal probate, and then we'll go into closing probate, because you can close formally or informally depending on how you open it. So just kind of a little bit of an overview of what we're going to talk about today. Also, I love this stuff, and I want to hear your questions. So as we go, I like to have more of an interactive presentation. So if you have questions, let me know. I'd like to address them. And I have a lot of slides to go through. My hope is to kind of cruise. But if there's something that's not clear or you guys have questions, just let me know. Okay? Cool. All right. So what is probate? I know I can't see you if you're on the webinar, but if you're in the room, how many of you have done a probate before? Okay, so some of you may be familiar with some of these steps. Hopefully, we can cover something that you're learning today. Probate is a proceeding overseen by the court. If there is a will involved or some testamentary document, the purpose of a probate is to prove that the will is valid. It's what the testator wanted. They had capacity to sign the will, and then it determines distribution of assets. If there is no will, then we'll talk about what that means and what it looks like. Basically, the probate is to determine heirs and distribution of assets. There's a confirmation of a personal representative. The personal representative follows through with the probate, collecting assets and distributing assets. And then, if there's any will contest issues, any ambiguity or construction issues, I'm doing a lot more litigation. I'm trying to keep this more of a broad level kind of CLE. But forgive me if my paranoia comes through when I have initial meetings with clients, because that's typically what I'm doing now is disputes and litigation in probate. So what is an estate? People often there's a lot of misconceptions about what is an estate, at least from the client perspective. An estate is everything that you carry with you during your life and after death. For federal estate tax purposes, that definition is actually much broader. So for those of you who have done probate and maybe have even filed a 706 or a state tax return for your clients, you realize that all of these things, all of what's typically included in a probate estate, plus more, is usually included in the estate tax return. So depending on kind of what you're looking at, when we talk about estate for probate purposes, we're talking about assets in the name of the decedent. So when I use the term probate, I'm typically referring to just the actual probate process with the court. You'll hear the term estate administration or estate settlement. To me, that's kind of a broader term that encompasses trust administration as well. So any of a decedent's assets that are being administered after death, I typically refer to as estate settlement or estate administration. And I know you can't read this. This is not to be cruel. So you're going to get all of these slides after today. So if you feel free to take notes, you'll be able to see these. They're just definitions taken right out of the probate statute that I thought might be helpful. Knowing now that you don't have the slides in front of you, this just seems like a cruel punishment. So I apologize. So for reference, the statutes that cover probate and proceedings here in Minnesota are listed here, 524 and 525. Throughout the CLE today, I've tried to include as many statutory references as possible. I haven't included all of them, but it should give you a good preview into what to look for in the statute itself. So I'm kind of a case person. I like to go through cases or at least give examples. So first impressions matter when it comes to probate. You get a call, say, from a potential client. Their loved one has passed away. They call you. Maybe you've never done a probate before. What do you need to look for? What information do you need to get started on a probate? So I'm going to go through some of those things. So typically what I ask for, I have a questionnaire that I have them fill out with all of their asset information for the decedent, where they were born, where they passed away, when they were born, when they died, whether they were found or not. That's usually on the death certificate. Any financial information, they're aware of any real estate, any debts, claims, expenses, and a family tree. Now, if they've gone to the funeral home already and done the funeral planning, they might have some of this information in front of them because they're going to need it to file a death certificate. But a family tree is especially helpful if it's an intestate matter where you don't have a will and you need to give notice of any potential heirs. We'll talk a little bit more about that. Family tree is just, I mean, if you can get that provided to you, that's awesome. You're saving yourself a lot of time. So I usually ask for that. And then look for red flags. You're getting a call from maybe, an adult child from a prior marriage. Decedent died. They present to you a copy of a will that was dated a couple days before they died. Maybe it looks like it might have been signed in haste. All of those things are what I look for, only because I litigate and I'm a little bit paranoid. But those are things to kind of keep an ear and an eye out for when you're talking to somebody initially or during an initial office conference. Use your gut. I mean, really, your spidey senses are going to tell you a lot. If something doesn't feel right, maybe you want to look a little bit further into that. So, you're meeting with this potential client. You want to determine the decedent's assets, debts, claims, and real estate. All of this is useful for the initial application because you're going to need to put on that application or petition what the decedent owned. So probate assets. So those of you who have done estate planning or any sort of probate, this might bore you to tears, but an overview of what probate assets are. So assets held only in the name of the decedent, bank accounts, cash, tenant in common ownership of real estate or sole ownership in real estate, stocks, bonds, securities, tangible personal property, jewelry, guns, pets, cars, all that kind of stuff. Unless it's held jointly with another person, or it lists the beneficiary of the asset as the estate. All of those things are probate assets. Non-probate assets, so things that typically do not go through probate or the probate process, include things with joint owners, so jointly owned assets. You know, if you have a surviving spouse come to you and they've been married for 30 years, they have adult children that are joint children with both of them, everything's joint, you might not even have a probate. We'll talk about that. Transfer on death designations, or POD, payable on death designations, avoid probate. Trust assets fall outside of the probate proceeding, and anything with a beneficiary designation. Again, if it doesn't list to my estate or the estate of the person. So second, determining the heirs at law, who's going to receive something. If there isn't a will, this is where that family tree comes into play, and whether there is a will or not, or a copy of a will, or maybe it was stolen or lost. Is there any proof that there was a testamentary document? So why does that matter? Well, testate versus intestate probate. So if the decedent did have a will, a codicil to a will, or something else that looks or feels like a testamentary document, you know, that document needs to be proven in a probate proceeding. PR is appointed of the probate estate, and then distributions are made according to that document. If there is no will or testamentary document, you proceed intestate in the probate proceeding, and the state of Minnesota actually determines how the assets are going to be distributed. So what is a will? Well, it's a document that states that you're appointing somebody to act on behalf of your estate as the personal representative when you pass away. It states where you want your stuff to go, what stuff you have potentially, and you basically can revoke it at any time. I've had 96-year-old clients come into my office for estate planning purposes, and they say, you know, we've been thinking about doing this for a while now. Well, you're 96, so you're still alive, so you still got some time. You know, it's revocable. They can create one, they could revoke one, they could redo it. So that's kind of the beauty of the will. A will does not avoid probate. That's also a misconception by clients. Often they come in for estate planning and they say, I want to do whatever it takes to avoid a probate. I want to do a trust, or I want to do beneficiary designations. Well, you know, that's great, but they're, were you waving at me? I'm sorry. Oh, I thought you waved. Sorry, I lost my train of thought. They come in and they say, well, I don't want to go through probate, so I just need a will. Well, that's, you know, the whole purpose of a will is to go through probate. So you have to explain that to clients. So when somebody dies and they bring in a will and they say, all right, so how do we get this taken care of really quickly? They did a will, so now we don't have to do a probate. Hold on, wait a minute. That's the entire purpose of it. So sometimes it takes some explaining on the front end. And so the benefit of doing probate, if you're also doing any sort of planning, is you get to see how it works out in the end. And then if you see a probate, how it works out, you know how to tailor your documents to avoid, you know, mistakes or omissions in the future. So again, contents of a will. I mean, you could be as specific in a will as you want. The basics are you're nominating a PR, you're determining how assets are distributed at your death, and you can create testamentary trusts for the benefit of beneficiaries. Usually you'll see that for grandchildren or minor children. So determination of heirs. I was a little naive on my first probate proceedings. I did some, you know, testate, informal proceedings where the decedent had a will. It was an older woman, she's in her 90s, no surviving spouse, no children. She designated in the document where she wanted her stuff to go. I had met with her, I drafted the documents. She told me she wanted to omit her, you know, first cousins. She wanted it to go to specific people. Great. At the time, I didn't think I had enough to have her give me a list of all of her family tree or her heirs. So when she passed away, when I was going to submit the probate documents, I didn't have all the heirs that needed to receive notice. So I had to do a little bit of digging, which could have been completely prevented if she had just put them on a sheet of paper and said, here are their names. So I say practice tip, you know, going in, maybe you didn't meet with the client, but at the initial meeting when you meet with your PR, your potential PR, see what you can get as far as heir information, because it's extremely helpful. If the will states a class of descendants, for instance, my grandchildren, but it doesn't actually list the names, then you've got to figure out who's alive and who fits into that class. So you're going to be doing kind of a family tree anyway. And for purposes of discussion, an heir is not the same as a devisee or devisee. Devisee is actually named in the will, and an heir is determined by the laws of Minnesota, who's going to take by intestate succession. And we all love this, don't we? I love this stuff. And actually, Mike caught it this morning when I initially got this. The first diagram, I just plopped it in there. I realized the first piece was actually wrong, so Mike caught that for me. I should have kept it in to see if anybody noticed. But, you know, I've actually had to do these diagrams, sit down, talk to the probate registrar, figure out whether it was a per capita then per stirpies distribution, because of, you know, who is an heir in the case. So, you know, this might bring up some bad memories for some of us, but it's a good reference. And also if you're drafting, you know, it's helpful to know what these terms mean, so you know exactly how the assets are going to be distributed when that person dies. So intestate succession. If there is no will, or there's no will that's been proven to be valid, or maybe it's lost, they could not find any sort of copy, nobody has any knowledge of it, then determination of heirs is especially important, because you're going to have to give notice to all the heirs, and that's going to determine who receives assets from the estate. The laws of intestate succession determine exactly how those assets are distributed. Again, this is something that I think a lot of clients don't quite understand. For instance, personal story. Before I married my husband, I met him. We were going on a scuba diving trip. I said, "Look, I'm an estate planning attorney. I know we just met. This is a little weird. Do you have your estate planning documents?" I'm not going to drown you or anything. You know, we had to have that discussion. But he said, "No, why do I care? Why do I care? I'm not married. I don't have kids. I have a successful business. What the hell? If I die, it's going to go to my parents." Or he said, "It's going to go to my brother." I said, "Well, that's a cute idea. That's not what's going to happen. It's actually going to be split among your parents who've been divorced for 20 years and don't get along. So how's that going to look?" He's like, "Where do I sign? What do I sign?" So I think that this is really important to educate clients on the front end, especially if you're doing estate planning, to let them know, look, yeah, I get it. You think you don't need a will and it's kind of a moot point, but the laws of intestate succession don't always go how they think they're going to go. So they can actually decide for themselves. And I think that's huge. Yeah.
How hard do you go looking for a will? Occasionally I see folks on the discussion list saying, "We think so-and-so may have made a will, maybe someplace in the Bemidji area."
Yeah.
And just kind of, these questions seem just pretty random and fishing. So how hard do you go looking?
Yeah, so the question was, for those of you on the web, how hard do you look for a will if you can't find it? And what resources do you use? Well, we have wonderful listservs through the MSBA. If you can kind of navigate where you think they may have gone, in what city or what attorney, you can usually email or call that attorney. You know, I put in my documents to look for a separate writing for 60 days. You know, I mean, it's in statute as well. If 60 days have lapsed and there's no separate writing, we're going to assume there isn't one. I guess it's up to the heirs how hard they want to look. I'm not usually going out and looking for them, although I'll send out some emails and call. It really depends on the situation. If it's all just adult children who are receiving by intestate succession anyway, maybe looking for the will is a futile, you know, task, and you want to just go informally intestate anyway. And I don't know if any of that made any sense with all the legal jargon. Does that answer your question?
Yes, thank you.
Okay. Yeah, I guess it's kind of case by case. You know, look at the facts. I threw this in here. This is my own really rudimentary graph. So if there's a surviving spouse takes a portion, if not all, based on the statute. Then it goes down the line. And so there's actually some really great resources out there put out by, I think, the judicial branch that has some great charts and things for determination of errors. So you don't have to try to decipher the language in the statute. But this is my own little rough thing. I threw this in here as well. So the share of the spouse. If there is a surviving spouse and you know they've only been married to each other and they have children, but all the children are joint with the decedent, yes, chances are the spouse is going to receive everything, even if there is no will. But there are circumstances where they do not, and that's laid out in the statute. So I just wanted to include this for reference later. There are exempt assets, there are family maintenance and allowances that come into play if there's minor children, adult children from a prior relationship, or surviving spouse. And so some of those exempt assets, I'm not going to dive too much into it today. I could do a whole presentation on it. The homestead, household furnishings, or tangible personal property, sentimental property, one vehicle regardless of value, and possible family maintenance are usually exempt from creditor claims. Why is this important to you as the attorney? Well, twofold. One, do you want to get paid? Yes. So you need to be conscious of the fact that if the entire probate estate consists of exempt assets, you should be looking at getting consent from all the beneficiaries or heirs to pay estate administration costs, including your attorney fees. Otherwise, you're going to do all the work and you potentially will not get paid. An O'Neill agreement, O'Neill is the case that I usually reference. That's the case that determined that you can consent to paying attorney's fees out of exempt probate assets. You just have to get that on the front end. So when you're at that initial meeting with the client and they're saying, well, they had a house, it was the homestead, a car, personal property was like $10,000, and you know, they have a minor child and they have this bank account. Well, that's a lot of stuff that is probably all exempt. So I'm on the front end going to get those consents, and usually I'll file them with the court right away to make sure that I get paid. Hennepin County is really good. The probate registrars here will take a look at it and say, notice that there's not a whole lot in probate assets, or it all looks exempt. Maybe you want to send in those consents. Hint, hint, nudge, nudge, like how are you going to get paid? So without having to go through that process and then have it kicked back, potentially get the consents up front. And then the PR must give notice of these rights to surviving spouse and children. We'll talk a little bit more about that. So if there is no will and it's an intestate probate matter, there is a priority of appointment for PR, and it's listed here. It's also in the statute. So if there's nobody listed in a will, or maybe all the people listed are just, they're dead, unavailable, they're not around, then you've got to look at the statute on who's got priority to be appointed. If you've got no surviving spouse and you have 3 people, 3 heirs, adult children, they all have equal priority, you should probably get renunciations or declinations to serve from the 2, appointing the 3rd, if they all agree on everything. And then third thing in the meeting, even if no probate is normally required, because you know there's no probate assets or it's a small enough estate and collect it with an affidavit, are there any issues that you should be looking for before you proceed? So, to probate or not to probate. So what I typically look at, if there's any real estate or there's probate assets over $75,000, so assets in only the decedent's name, typically I'm looking at it at a probate. Maybe informal if there's no issues, maybe formal if I see any of these other things that are going on. There's a medical assistance claim, say for a surviving spouse or the decedent, and it's possible that that claim puts us over what assets we have. It could be an insolvent estate. I'm going formally. Minor beneficiaries or unknown heirs, formal. Issues with the will or testamentary documents, formal. You want to go in front of a referee or judge to say, yep, that copy of the will is valid, go ahead, but you want to make sure you get the blessing on that, and that's going formally. And then family conflicts or potential litigation. I always have my ears and eyes open, and I'm just going to kick a probate into formal probate if I see any possible litigation in the future. So when is no probate required? Well, if the decedent had less than $75,000 in probate assets, no real estate in only their name, or no, tenants in common real estate, 30 days have lapsed since the death, and no probate has been begun or started in any jurisdiction, then you can do an affidavit for collection of personal property. And of course, today we're talking about the mndocs software. This stuff is great, you guys. So I've been using CLE Pro here and there, some other forms that I kind of inherited over the years, and then started using mndocs. This is actually pretty awesome. I've been using it now for more and more of my inventories and final accounts. But you can also do things like the affidavit for collection of personal property. If you don't want to use the form that's online somewhere else, this will actually auto-populate once you input the client information. So it's pretty slick. So probate's necessary. You've determined, yep, based on the facts and the assets, we need to go through probate. What's my time frame? Can I file now? So you have to wait at least 5 days to file for a probate, unless you're filing for what's called a special administrator to be appointed to protect and preserve the assets in the estate. This is often the case if there's questions of fraud or mishandling of funds. Maybe there's a sale for real estate that's happening very quickly. Maybe, there's just other issues that you want to make sure somebody's got a hold of these assets right away. You can't wait 5 days. So you file for the special administrator. Special administrator acts until a personal representative is appointed in another probate proceeding. So after 5 days have lapsed, if no probate's been open, you can open one. You have up to 3 years after the decedent dies to open a probate. At that point, then you're looking at doing a determination of descent and getting a decree of descent. After 3 years, a lot of what I see is there was no probate when the decedent died 5-10 years ago. Mom and dad had held everything jointly. Didn't realize the cabin property was still in mom's name when they both died. It's been about 10 years. So now we're looking at, well, we don't go through full probate. It's been over 3 years, so we do the determination of descent. You attend a hearing. The court approves distribution of property. They determine who the heirs are, and you take care of it in one fell swoop, usually. So, pretty cool. Okay, informal versus formal. Any questions thus far? Nobody? Okay. I hope I'm not just telling you all things you already know. Okay, informal versus formal. So this is just kind of a really quick summary that I'm kind of a tables checklist kind of person. So this is a nice comparison of the two. So what you're filing in an informal probate is called an application. What you're filing in a formal probate is a petition. And so this just kind of compares the two. If you're going informally, it will always be unsupervised. That's just the nature of an informal probate. If you're going formally, you can choose to have it supervised by the court. And we'll talk a little bit about that. So you'll have this in the slides. It's kind of a nice reference going forward. So why choose formal? Well, if you see any problems whatsoever with the documents, the heirs, the potential distributions, maybe the timing was a little off. I've been presented with handwritten wills that were signed maybe 3 days before the decedent passed away, omitting a couple children. Okay, I think any normal person, any reasonable person would say, that seems a little bit odd, doesn't it? Okay, well, we're going to give notice of a formal hearing, and we're going to go in front of the judge and make sure that this will is valid. That gives people an opportunity to formally object. If there's any real estate issues that could potentially arise, maybe you want to kick it into formal just to get it through the court and get the court's blessing later. And then insolvent estates. I tell my clients all the time, it's more expensive to die poor than it is to die with, middle class amount of money. And the reason is you have a much more complex probate. Oftentimes, if you have an insolvent estate, you have to do a priority of creditor claims, who's going to get paid in what amount and what order. and you have to have a formal final hearing to close a probate. You know, it's just a more drawn out sort of complex proceeding. And you would think it wouldn't be because they didn't have much when they died. Well, that's not always the case. So I have one right now where we have an MA claim, an IRS lien, a judgment, prior divorce with a judgment. She had a trailer home that's missing the title, and we're selling the real estate, and there's title issues. So I told them on the, you know, at the get-go, I'm sorry, I know that your mom probably didn't have a lot. Here, please sign these consents so I get paid, and this is going to be very expensive. And it is. And it's not because I'm just dragging my feet, it's just the nature of the probate. So all of these things could potentially put you into formal. When in doubt, just file formally. Don't even mess around with it. Go have the hearing. It's a little bit longer process at the beginning. You have to make the appearance, but it's worth it. If you end up getting kicked into formal anyway, you got to reschedule a hearing, pay another filing fee. It's kind of a pain in the booty. So, and I've just listed here kind of what I typically see with issues with devisees or heirs, some problems with the will, real estate issues. So practice tip here, I'm a big proponent of nip it in the bud. If there's any real estate, even if you have no question about who the owner is, ask the client if you can get an O&E report or title report on the property right away. It's $100 to $200 depending on the title company. It is worth it. I've had clients call and say, I have a closing in about 2 weeks, 3 weeks. Can we still have the closing? Probably not. But let's do a title report just to make sure that, you know, this closing doesn't, no issues come up right before the closing, and then it doesn't have to be stalled again if we can get somebody appointed. So that's my kind of tip for today. This has helped tremendously in a lot of my cases, just getting that O&E. And I don't know if any of you do a lot of real estate work, but I usually get a call about 3 days before closing that there's some major issues to fix on the title. So if you can do this and the client pays for it ahead of time, you can usually get those issues resolved well before closing. And then insolvent estates, again, you're probably looking at formal. So I've just copy and pasted the mndocs available probate documents that are on the software. I mean, it's hard to see here, but really anything that you'd ever need, honestly, the forms are there. And I think Mike will talk a little bit more about the cost and all that stuff. Honestly, it could be, you know, thousands and thousands of dollars. I know it's not.
No.
But it would be worth it because this has saved a ton of time. You save the answer file, for any of you who've used it, you save an answer file with all the input information. I usually put that in my client folder on my shared drive or wherever, and then I bring it up and it auto-populates everything except the new information I'm putting in. It's pretty slick. So that's just a list of the documents. All right, so informal proceeding. So again, I'm going to kind of go through the process for an informal, and then we'll come back to opening or filing for a formal, because some of these things are similar or the same. So the process includes you file an application with the court. Usually there is no hearing, or if there is, like in Hennepin County, it'll be a telephone hearing with the probate registrar. For those of you who've done probate in Hennepin County, it's Alana Warrens or Julie Peterson. And they're usually pretty quick to schedule those if they get the application. You'll then get notice of appointment of the PR, and you serve that notice by publication and mailing on all the interested persons. You file the affidavit of mailing, affidavit of publication with the court, and then they issue letters testamentary or letters of general administration. So depending on whether there was a will or not will determine the letters that are issued by the court. So filing the application. This is where that family tree comes into play again. So you're going to need to know where the decedent lived at the time of their death to determine the domicile or residence and whether the venue is proper. So I've had a lot of questions arise. Okay, mom had real estate in Cass County, had lived up there, moved down with the daughter in, say, Anoka County, but died in Hennepin County. What do we do? Well, where she owned real estate is a potential. and was she truly domiciled in Anoka County with the daughter? So all of these questions, you know, you want to ask your potential PR client so you can include it on the application. The death certificate's pretty helpful too. I mean, it's going to give you date of death, date of birth, place of death, whether they were found or not. Make sure you include that on any application. The registrar needs to know if the body was found or not, which I guess makes sense if you think about it. There could be suspicious circumstances potentially involved in the probate. So include that in the application. By their nature, informal proceedings have much less court involvement. That's kind of the point. They're unsupervised. You get the PR appointed, you give notice to everybody. They can then begin their work and they don't need to get the court's approval and everything. And again, usually no hearing is required. So again, you can do the application here on Hot Docs. You can also do the notice in order for hearing or appointment of PR. And that's what you'll end up, you know, giving to the registrar to sign off on, and then you publish and serve notice. So an acceptance and oath, letters will not be issued until the PR says, yep, I accept, I take the oath, I will do my best, I want to be appointed. I will usually have them sign this and date it when they sign the application. Might be jumping the gun in some counties, they don't necessarily like it. You know, some of them want to wait until they've signed off on the notice for the acceptance and oath to be signed. I do it right away. I haven't had many issues with it. Then you just file it, and then it's done. Letters are issued once you serve notice. Pretty slick. Telephone hearing is pretty straightforward. Basically, the probate registrar is going to go through the application, the will with you, or any testamentary documents, ask questions, and I know Alana is really good about talking out loud while she's going through it in Hennepin County. She'll say, okay, decedent, yep, check, 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 check. Oh, question about this, check. And usually pretty quick, 15, 20 minutes tops, usually. They can deny the informal application for any reason. They aren't necessarily going to tell you why, and it's not their job to do so. So it falls on you as the attorney to make sure that you preempt any issues that might happen. Rather than go through all this process, have the telephone hearing and then have the registrar say, you know, we're denying the application, kick it into formal and pay a new filing fee. I mean, you're out potentially a couple weeks at that point. And if you have any real estate issues or closing, that can be a huge issue. So just pay attention when you're filing your applications. Just really scrutinize your own work, because I know when things get busy, it's really easy to, okay, yep, it's informal, it's easy. Alana and Julie are really awesome about it. I don't know about other counties in greater Minnesota if they're good at catching these things. And it's just kind of a pain in the butt if it gets kicked out of informal probate. So notice, this is huge, especially in litigation matters. I'm very conscious about this kind of stuff. So notice of appointment of the PR is given after you have the telephone hearing with the registrar and after the notice and order are issued in an informal probate, which is different than a formal. So basically the PR has been appointed. The registrar said, yep, it's all okay. Now give notice to all the interested persons. So you're filing a notice by publication in a legal newspaper. We just listed who potential interested persons are. So publication in a legal newspaper for 2 consecutive weeks. So once per week for 2 weeks. Publication has to be done at least 10 days before the hearing. And some counties actually arrange for publication, which is pretty great. So they'll say, yep, don't worry about it, we've got it. Oh, okay, sweet. And then they'll actually get the affidavit that publication has happened directly from the publisher. Not so in Hennepin County. We usually use at our firm Finance and Commerce, pretty typical legal newspaper. They're usually quick turnaround too, so it's pretty straightforward. So you send in the notice, you look at a proof, you approve it, you pay their bill, they publish, then they give you the affidavit. You don't usually give the affidavit unless you paid their bill, which makes sense. And then notice by mailing, any of the interested parties, including known creditors, must get mailed notice. You can clip out the publication and send a copy to them, or you can send the actual notice, copy of the notice. So you need to send it to all interested persons, and then get the affidavits right off the get-go. So you're saying, yep, I sent this on this day, and then you file those affidavits with the court. There's also the spouse and children rights that we kind of talked about. You have to give notice that the spouse and children have potential rights to those exempt assets, family allowance, and possible statutory allowances. So I usually include that in my notice. I have a separate notice for spouse and children and one for other people like creditors or other heirs. And then again, the affidavit for publication is filed with the court, and then letters are usually issued. The affidavit of mailing. So how many are you familiar with filing and giving notice to the Commissioner of Human Resources? Human Services. Okay, so you guys are familiar with this. So I do a lot of MA work. I'm an elder law attorney, so I deal with benefits all the time. I do a lot of estate recovery. So there could potentially be a claim against the estate. There also could potentially be a lien placed on real property. So that's why that O&E report is helpful if there's any real estate. So the affidavit is then, so you give notice to the Commissioner of Human Resources. That affidavit is then filed with the probate court. And usually you get a letter, a generic pre-filled letter, just saying the decedent did not receive any medical assistance, or if they did, and then they'll usually tell you the amount. The county will come back with a breakdown of those amounts. So, helpful to do. And actually, I like to file that right away. Helpful hint on that, you're going to need to include the social security numbers. I'll be right with you. Yep. Include the social security numbers for the notice to the commissioner of both the decedent and spouse, whether deceased or surviving. And the reason for that is there could be a claim against the decedent's estate for MA benefits received by the pre-deceased spouse. And so for the social security numbers, I'll usually do a confidential information form. So it's a separate form that I send along with it, just saying, see confidential information form. I then file the notice and affidavit with the court, but it doesn't have the socials on it. So be aware, if you are filing this, you either need to redact, you'll get in big trouble, or just send it, without the confidential information form to the court. Yeah.
Do you try to get that affidavit in all?
I send it out automatically. Yep. And I do it not only if there's real estate, because there could be a claim against the estate for a pre-deceased spouse. Could be a first spouse and they had 3. They were married at the time the first spouse died. So you can uncover a lot. And then if there is a real estate closing, usually providing that letter that they give saying that no MA was received is good enough for them to go ahead with the closing. You don't necessarily have to get the clearance certificate for the closing. Yeah, does that answer your question?
Yeah.
Perfect. Okay. Then the statement in order for probate. I hardly ever see this. I've got my paralegal really well trained. It sounds awful, but this is issued, once the registrar approves the application, this will typically be filed, and I usually have my paralegal serve it on all the interested persons. I serve everything. I err on the side of, I don't want anybody to say that they didn't get notice of something, they weren't aware something was happening. Anything that I file or I get, I serve on interested persons. It's a little bit more costly and time consuming, but it saves a lot in the end. So what I do for the statement in order for probate, if there's a closing happening, as you know, if you've done this before, you need to get a sales package. So it's the certified documents from the court, usually involves a statement in order for probate, certified letters, testamentary or of general administration, and a certified will. So that's what they're going to need for closing. So this will be part of that sales package. For a long time, I was like, what are they talking about? I got the letters. Well, yeah. So the letters are really the bread and butter, are what people are looking for. Yeah.
What's the difference between that
question was, he has a client with property in Wisconsin,
Yes.
and Wisconsin's asking for exemplified records. I have never encountered that before. My guess is, you know, we have the real estate white pages, the title standards. I don't know what Wisconsin usually requires. It could just be a term that they're using for the certified copies.
Well, it's interesting, the reason why I asked it, because I saw, when you do file and there's different copies that you can order, they have certified and also have exemplified, separate copies.
Yeah, I've never requested them. Has anybody ever requested exemplified? Yeah, can you explain what that is? Because I'm curious.
Yeah, it's a more formal process that they go through with documentation to show it's exemplified. I think they get some kind of court signature that goes with it.
Okay.
And some additional documentation, and then it's sent over to, I know Wisconsin requires it.
Okay.
How much longer does that process take before you exemplify?
Doesn't usually take too long. I can't remember how long it took them about a year ago, but it takes a little bit more time to do that. I would think so.
So it usually takes about a week, and you can request that. So for the sales package, then I'm wondering how that differs from having like the court administrator sign off. I wonder if it's a judge or something. I'm curious
Yeah,
now.
there's more signatures, more documentation
Okay.
required, yes. It's a little more formal process, but they have to get, I can't remember all the signatures that you have to get, but you have to
Yeah.
get at least a couple more steps involved.
Okay. So it's like herding cats.
Yeah.
Okay. And you pay a little bit more for it.
Right.
Right. Okay. Thank you for that, by the way. That's helpful. Okay, so letters, again, everybody, that when you are dealing with a PR, they're going to call you immediately after a hearing or immediately after a telephone hearing if they hear about it. They're going to say, where are these letters? Are they coming? What's going on? Why is it taking so long? Okay, just take a little bit of time. So you have the telephone hearing with the probate registrar. Let's say you've already filed the acceptance and oath. All the notices and affidavits have been filed. Letters are issued. You look on MnSys. They're there. Now what? You have to request certified letters. And it takes a little bit of time administratively. It takes a couple days usually. So you just have to tell your client to relax. It's coming. You are appointed. We just don't have the certified letters yet. I know in Hennepin County, for some reason lately, I haven't been getting the filing notice that letters have been issued. So I've had to check on MnSys to make sure that they've been issued. Could just be kind of a glitch. I don't know. And then usually when you sit down with a client right away, before you've even filed anything, they say, I went to the bank to collect my mom's account. I need these letters. Can you write the letter? Well, okay, no, that's what they're talking about. So you have to get somebody appointed, potentially. All right, so the administration process. So that's getting somebody appointed. Now the PR is appointed. They've got letters in their hand. They can go out and run with it. Scary notion. So their duty is to collect assets, pay any debts, claims, expenses, including your fees, and prepare a final inventory and final account before distributions are made. Collecting assets, so really, I mean, I take a pretty hands-off approach unless the PR needs my help. I figure they probably don't want to pay me to go to the bank and collect these assets for them. So I put in a letter very detailed instructions about what to do. Here's a tax ID number. Here's how to open the estate checking account, deposit the funds, open, a small interest-bearing account, collect all the liquid assets. Sometimes they need a little bit more help and they're willing to pay me for it. That's just a personal thing. I just kind of take a little bit of a hands-off approach. Some attorneys, and I'm kind of leaning more this direction, if there is an estate checking account, they will actually hold the checkbook. I'm finding that although I don't really want to have that, I don't want to be responsible for it, I'm finding more and more maybe I need to be as I administer these probates. The PR's not really on paying some of the claims, they're not really on writing the checks, or they're not really good at record keeping. And so I want to make sure I'm getting those estate checking account statements every month. I have them send a copy to me, but sometimes I don't have the register to compare it to. So that's up to you guys in practice how you want to handle it. some of the attorneys in my office, and I'm probably leaning that direction, will actually keep those checkbooks. And then real estate, it's important to note if there is a closing coming up, they call you and say we have a closing in 2 weeks. Chances are you're probably not going to let them keep that date. It's just not going to happen. We can talk about formal administration. Formal hearings are usually scheduled out about 6 to 8 weeks, depending on the county. So right there, that's an obstacle for the closing. If you're going informally, you can get them appointed pretty quickly usually, but you have to wait 30 days from the date the letters are issued for the PR to sell, encumber, or transfer property. And there's an additional 70 days you must wait for the Commissioner of Human Services to either get the clearance, that letter saying that no MA benefits were received, or you can obtain an actual clearance or waiver from DHS. So there are some limitations on real estate. Oftentimes clients are pretty understanding. If they come to you a week before closing, you know, I tell them I'm not a magician. I work quickly and I'm pretty efficient, but this is not possible. So it's managing those expectations too. And then filing the inventory and preparing the inventory. The values on the inventory are date of death values. So if you get an appraisal on the house, make sure that the appraiser knows that it's date of death value, not 2 months after, not 2 months before. You want the date of death value. It's especially important if it's an estate tax return involved, a taxable estate. You're going to want the date of death value to see if there's any gain on the property. Everybody, so surviving spouse, devotees, interested persons, creditors, they are potentially receiving a copy of the inventory. I file it, again, I just serve it on everybody. Most counties are kind of up in the air whether it's a true requirement or not. A lot of them are pushing you to file them, at least not in informal administration. Sometimes you can get away with just filing the final account and closing, but it depends on the county. Yeah.
If you do not have an appraisal yet, how do you handle it for the inventory if you don't use this property?
So the question was, how do I deal with valuing a property if I don't have a formal appraisal? Depends on what we're doing with the real estate.
Or not just real estate, it could be business. Any type of valuation for any of the assets that you don't know what the number is yet.
Yeah.
Sometimes takes longer in that time period.
Yeah.
How do you handle that one?
So I typically request the last 3 years of tax returns along with all of their documents. And I see some raised eyebrows. The reason is I can look at gift tax returns and I can look at potential business tax returns and see what the value of the company was last year. If they haven't set the valuation, say for an LLC this year, I can at least see what it was last year or see what the inventory amount was. It gives me a good idea. Usually, you can find somebody within a company, for instance, that has a valuation amount, fair market value, and can give that to you as of the decedent's date of death.
If you don't have that, because it's not.
So is it a business?
Yeah, you took the best estimate that you have on filing it, or you put caveat.
So you're talking specifically about the inventory, not on the initial application.
Oh, okay. That's
okay. Yeah, because application's the values on an application are going to be vague because you don't have a lot of information potentially. Hopefully by an inventory, if you need to file one, you can either obtain a business appraisal by a professional, or you have a good estimate from the business itself, some representative.
I'm also thinking.
So, okay, so it's going to be dependent on the case and what you're dealing with. Yeah. Okay. Any questions about that inventory? Okay. You can contact the court to determine if the inventory must be filed. I mean, really, I just, as a matter of practice, it makes it a heck of a lot easier to actually do the final account if I have the values on the inventory. So I do them in my practice. But if it doesn't make sense for your case, if it's pretty straightforward, informal probate, maybe you call the county and say, look, we're not going to file one, we're going to close soon. they are probably going to be okay with it. So the inventory must be filed with the court within 6 months after the appointment of the PR or 9 months after the death of the decedent, whichever is later. So as soon as I get a death certificate and the letters are issued, I will look up these 2 dates and I will tickle this on my calendar to determine when the inventory will be filed. So again, the inventory on mndocs is really pretty great. So it takes all that information then from the inventory, and when I do my final account, it already inputs all of that asset information, and then I can calculate my gain and everything from there. It's pretty slick. So settling claims, during the administration of the probate, really the PR has all the power. I mean, really, they can do whatever they need to do to settle claims, sell or encumber property, lease property, hire professionals. You know, they can do what they need to do to settle the estate. And then a creditor, so creditor claims that can be filed against the estate by filing a statement either with the PR or with the court. They could file a demand for notice before probate's even opened, or they could send a letter after it's open and say, hey, yo, by the way, you owe us some money. The decedent owed us some money. So creditors have 4 months after the date of the first publication to submit a claim. I tickle this date. It's a pretty key date. Once that date occurs and I don't receive any more creditor claims, or they've all been paid up to that point, you can potentially close. You're past the creditor period. Medical assistance, on the other hand, has no statute of limitations. It's its own beast. You'll see all the exceptions in the statute, except for 256B.15, except for claims for medical assistance or government benefits. So know that. That's why it's useful to get the affidavit or serve notice on the Commissioner of Human Services to make sure you have it in the file. Because then once the creditor period runs, you know, you're pretty much in the clear then. And then you have 2 months to disallow or allow a claim after the creditor period expires. I don't run into this a lot. Usually we're pretty aware of what the claims are going to be, and usually they're filed timely. I haven't encountered it a lot where I get a late claim and I have to disallow, or it's a disallowed claim because it's unreasonable or something that doesn't apply. So I guess I've been lucky in my practice. I know that you guys probably can't read this. If I didn't have my glasses on, I couldn't read it from here. So this will be in the printed materials. It's just sort of a timeline going through 1 year, and how creditor claims are handled and what happens during that year. So in an insolvent estate, if you have less assets than you do debts or expenses, well, you better hope that you got the consent to pay for your fees. But you also have to lay out a priority of claims, and you have to close formally. The court's going to want to see what's in the estate account, what are the debts and expenses laid out by priority, like here, and then you have to get it approved. So it's important. This is an important reference. You know, as a mortician, I always joke that I always got paid. I was either top priority or second in line, so I've never had to worry about it. But if there's an MA lien, say, on real estate, a lien on the property, that's going to trump everything. So that's something to be conscious of as well. And then tax returns, I've just for reference kind of put up here the typical tax returns that could be filed in a probate estate: individual and fiduciary income tax, federal and Minnesota estate tax, and then possible election for the qualified small business and farm deduction. We now have an accountant attorney in our firm, which is so awesome. So I can just walk right around the corner to her office and say, I have a question about the 706, which you're doing for me, which is awesome. So we actually do most, if not all of these in-house now, which is pretty cool. Distribute assets. So after all the assets have been collected, debts have been paid, tax returns have been filed, you can prepare the assets for final distribution. You prepare the final accounts and proposal for distribution, which is signed and looked over, the final account and proposal by the PR, and then served on all the interested persons. If it's a supervised formal probate, or you start informally and close formally, you're gonna need to go in front of the judge to get this approved and appear at the hearing. I think we have a question. So insolvent estates, you cannot distribute any assets before they are approved by the court, or you get the court order. The same is true for formal supervised probate. And is there, how do I check?
I don't think there was a question. I can
Oh,
check with
okay.
Joe, but I think he was just saying that these materials are available for the benefit of our
Oh,
online
great.
attendees.
Okay, perfect. All right, so I've been talking for an hour, and I know some of you are yawning, so I'm gonna cruise. Okay? All right. So, minor
I'll check on that
distributing.
question.
All right, perfect. So, if there are any minors who are going to receive anything, maybe you weren't aware when you first met with the PR client, it's better to close formally if there isn't, say, a testamentary trust created in the will, or there haven't been things accounted for, like an UTMA account, in a will. Making a distribution to a minor is a no-no. You need to file, I think the statute says for a guardianship of the minor, but anybody who does this knows it's actually conservator. They're going to handle the funds of the minor. So before you can make distributions to any minor, they have to either have a custodial account, a conservator, or a trust created for their benefit. And then receipts, I am a proponent of CYA. That's the legal term. You get consents, you get receipts, you serve everybody, because you know what? Somebody inevitably in the end is going to come back and say, I didn't get that. I didn't get that car. What? You have the title and you signed a receipt. Oh, well, there you go. Okay, so if you get a receipt, chances are you can CYA a little bit. The language of the receipt, so I have two. Usually tangible personal property, so stuff is distributed before the full assets are distributed when you close. So I will get a receipt for tangible personal property, and I'll get one at the end that says each of the devisees or beneficiaries receive their, quote, full distributive share. They've signed off, it's said and done, they got their check, we close, and I file all of it. Any questions? It's a good practice to get it. Even if you don't really need it, everybody gets along. You never know in the future something might crop up. Oh, and if there is a trust as the beneficiary, so you're probating a pour-over will, those of you are familiar with that, the trustee signs the receipts. Okay, so I was going to cruise through a formal probate. So, formal probate. All right, here's the general process and how it differs from an informal. So, rather than an application, you're actually filing a petition with the court. You give notice of hearing to all interested persons before the hearing occurs, because you actually have to appear. In most counties, if it's an unsupervised formal probate, they will waive a hearing if no one objects. But you still want to notify your client, the petitioner, to be available and potentially present on that day. So if you don't show up, so for instance, I had one in Washington County. I said, look, nobody's fighting, but we need to go formally. We lost the will. Here's a copy. Nobody fought it. We gave notice. The hearing occurred. We did not have to appear. My client lives in Tennessee. I made sure she was available by phone and wrote a letter to the judge ahead of time saying, do you approve of a telephone hearing if needed? They said, no need. If anybody shows up to object on that date, we'll just reschedule it and you'll get a notice. So most counties, even for formal unsupervised, do not require a hearing. You still have to give notice of it to all interested persons. There's a formal hearing on the petition. If nobody shows and nobody contests, usually the order will be signed. And I don't have on here, it's the letters are usually issued at this point as well, because you've already given notice, the hearing has occurred, and if nobody's contested it, if the PR is appointed, the letters will be issued. You can go supervised or unsupervised. Supervised is very restricted. You are truly incapable of doing distributions without the court's approval. I have had cases where I've done it because everything along the way is going to be contested or litigated. I'm not doing anything for my client's liability without the court's approval. So I've done formal supervised. Sometimes you can accomplish what you need, proof up a will with a formal unsupervised, and you could even close informally if it turns out nobody's fighting. So you have some options here. I err on the side of looking forward and what's possible, rather than a wait and see kind of attitude. So again, just kind of a comparison of both. If you open formally supervised, you have to close formally. If you open formally unsupervised, the court's not overseeing everything, you can still close informally. We'll talk about what that means. We're getting there. All right, so all formal supervised, again, must close formally. The benefit of opening formally and closing informally is, well, there's a lot of reasons why you might do it. Cost is one, then you don't have to appear at a hearing. If everybody gets along, you get consents from all the beneficiaries or interested persons. They've either been paid, they've received their share, they're not contesting anything, they waive a hearing. You're good to go. There's no reason to have a hearing if everybody knows and everybody consents. So there are some reasons why it's a benefit to close informally. And then when to close formally. So this is more for future reference. If you're in doubt, if you say, I'm not really sure. If we give notice about the final account, it's possible that one of the beneficiaries could contest it. Maybe you just want to go supervise and have the hearing and lay it out there. So to close informally, this is the process, what needs to be filed or done. I find this extremely helpful. I wish I had something like this when I was starting out, actually. So if you're ready to close. All the assets are kind of in the estate account. You prepared the final account. You're accounting for everything that's already been distributed and needs to be. You've done the inventory long ago. So the funds are waiting to be distributed. You are going to serve the final account, potentially send consents to the final account and waiver of final hearing along with it to all the interested persons. Prepare receipts. So when you do finally make the distribution checks, write them out. You have everybody sign off on a receipt. You file a statement to close along with those receipts and make sure that the fiduciary income tax returns are all filed the 15th day, 4 months after all the assets are distributed. Again, tickle that on your calendars. All right, so final account, it's basically a balance sheet detailing all the ins and outs of the estate account and documents exactly what's available for distribution, for the final distribution. The date of death values from the inventory are helpful because it's going to show whether there's a gain or loss on any given asset. Final account, there's no statutory requirement for a final account, but I mean, again, especially if you want to close informally and you open formal, it may be beneficial to do the final account and give the consent so everybody's aware of what's going on, it's all transparent. So I usually file final account, the proposal for distribution, laying out who gets what. Maybe it's not equal shares, maybe there's already been interim distribution, so it might be unequal or unequal, and the receipts from the distributees. File all of them with the court. And then in an informal, you have a statement to close. So that's where the PR files and says, yep, we finished everything. Here are the final account proposal and the receipts. I'm done. I want to be discharged. If there's any bond, I want the bond to be discharged as well. That's filed with the court. And then, so basically after the creditor period runs, you're free to close. If it's a formal supervised, you have to have the final hearing. Possibly a priority of creditor claims has to be presented to the court. Otherwise, if there's no claims, everything's been buttoned up, 4 months after the letters have been issued or publication happens, creditor period runs, you can close. And again, you'll get all of this. This is just going through it in detail. So I'm going to leave it at that. Any questions? Ooh, yeah.
I have a question. So on your end doing probate, when somebody comes to you with a will, I'm trying to balance the probate versus non-probate.
Yeah.
Everybody's trying to be non-probate.
Yeah.
So I just logistically, what does it look like if you try to be non-probate in real life? So for instance, one way somebody could do it is do a transfer and death deed to the property. Well, so what messes up probate for that same property and what messes up the transfer and death deed? Like, for instance, you're in medical assistance. So what does somebody avoid by doing the transfer on death deed, or what do they not avoid?
So the question is, basically, how does a transfer on death deed for real estate
Or a trust?
or
Either of
trust-
these like probate avoidance things that we do.
Yeah.
They avoid probate maybe, but do
Yeah.
they avoid the logistical nightmares that come into play with medical assistance and
No.
litigation? Exactly.
The short answer is no.
Right.
A trust, a TOD, they don't avoid any sort of claim for MA or medical assistance benefits.
And do they hire you to work through those issues just like they would hire you if it were in a will?
Yeah.
So what would you say to people that are motivated to avoid probate and do revocable trusts or transfer of death deeds?
So I'm not in the business of selling people something they don't need.
Mhm.
And I tell that to my clients all the time. They come in, I want a trust. My neighbor has one. I heard that I can do an MA trust to avoid MA claim. No. I mean, really what I look at is what are the circumstances? So pros and cons, trust versus will and going through probate. Probate's not this dirty word. It's become a dirty word, and I'm not really sure why. People want to avoid it at all costs. Let me tell you, I have trust administrations that are not going through the court and probate that are just as expensive. If you plan well, even going through probate can be less expensive than doing a trust. As far as the TOD goes, the transfer on death deed, great, but they're taking it subject to all claims, not just an MA claim. So in order for them to do anything with the property, so let's say I have a condo, and I have, this is usually the case with my clients, they have a condo, right? It's worth about $150,000. I received MA before I died, and I've got a $50,000 MA lien, and I've got a $50,000 mortgage. I give it by transfer on death deed to my two siblings. Great. Now they just have a huge liability. They've got to not only file, they transfer the property into their name subject to these liens and encumbrances. The mortgage probably has a due on sale clause. So that mortgage is due immediately when they try to transfer it. They got to come up with $50,000 or sell it. And the MA claim, the property cannot be sold until that claim is paid, or they're going to keep the lien and it's going to be paid at closing. You know, they can either get a clearance certificate or sell the property. So TODs are great. They're not an answer for everybody. If you're going to leave to more than one or two people, and there's any question those people will die before you as the grantor, don't do it. Or at least give the caveat, they may need to come in and redo this, or it's void potentially, or you're going to probate anyway if one of the beneficiaries dies. Yeah.
So along those same lines, from your end as somebody that does probate, what frustrates you with people drafting wills? What are some things that you run into? You're like, well, if you just would have done this.
You know, I don't see a lot of terrible drafting from other attorneys. What I see more, maybe it's because I'm doing more and more litigation, I'm seeing the holographic, handwritten, amended, you know, here, mom, sign this 3 days before you die, that kind of situation. So they're not seeing an attorney. LegalZoom, by the way, hey, great. Go and do that, because I'm going to make a hell of a lot more money on this when you die than I would doing the estate plan. I mean, seriously, and I'm upfront, I say exactly that. Like, well, what do you have against LegalZoom? Nothing. Do it. Oh my God, yep. It's gonna have blank spaces. It's gonna talk about children you don't have. They're gonna be a guardian for who knows who, you know, your dog. So,
To make you all laugh, I
Yeah.
have a great story. It's my complete failure as a estate planning attorney that I didn't get my sister-in-law to do a will because it was a privacy thing. She didn't want me to have anything to do with it. So she did a LegalZoom and she filled in the blanks. And one of the blanks was, I leave my car to, I shouldn't know, this is all true. I leave my car to blank, whoever needs it. The second thing was, I leave my house to the women of the family.
oh,
And
good.
she died a year and a month ago, and it's still in.
Yeah.
And there's not gonna
Yes.
be anything left, because you get it all.
That's horrible. That's horrible. Supervised. That's very, yeah.
My sister-in-law,
So
yeah.
great intentions, right?
Yeah.
So that's why if any of you do estate planning, it's good to do probate, because then you see, oh my God,
That's why I came here, I'm like, tell me what I'm doing wrong.
yeah, no, I think your intentions were good, right? And if it was, you know, you did everything you could, that's not your fault. But I mean, it happens all the time. I have friends that just came in, married couple, and they said, well, they'd emailed me about 9 months ago with these LegalZoom documents, and I said, well, I'm not really prepared to look them over and make amendments, because I just rewrite the whole damn thing.
Mhm.
But, you know, you might want to consider maybe this provision, or maybe take this out, or look at this. They came in now after 9 months, sat down and said, look, we haven't even signed those documents. I'm like, oh, okay, well, you know, it is what it is. You can't, you can only advise, right? So, yeah. Anywho, yeah.
I know it, again, might be a little bit outside of the purview of this class, but sort of piggybacking off of the previous question. We talked a little bit about transparent debt fees and taking such as all creditor claims, including MA claims. But if you created a trust during the lifetime and then say, you know, mom has the house and transfers it to a trust, is there any protection from MA in that scenario? Even if the trustee is someone other than the person living in the house? Or
Well, did mom create the trust?
mom created a trust and then transferred the house to the trust during the lifetime?
Then no. Because she had access to all those funds as a grantor of that trust. Unless she completely gifted it, got it out of her name, and somehow got an MA and went through that process. No, if you have access to any assets, whether they're in a trust or not, potentially they're available for an MA claim, or will make you potentially ineligible for benefits if you're talking about whether it's still alive. So that's a whole, we could talk an hour about that. But no, yeah.
If you have an MA claim that exceeds the value of the estate, can your heirs and refugees still consent to paying their fees?
No, well, is it a claim or a lien in the house? Because I have one right now where I sat down with the other attorneys. It's a claim against the estate. There's real estate. They consented to use the real estate proceeds for estate administration costs. Follow me here. But it wasn't, there was never a lien filed against the property, so it's not a secured interest on the property, which would trump everybody's. So my argument,
Sell it and you take your money.
well, you consented to use that. Of course, the county and DHS, we work closely with them. They're not terribly thrilled about it, but it's like, well, you could have filed a lien against the property and collected that. Instead, you did a claim, and so what we're doing then is we're paying our fees out of this, and we'll get paid out of, you know, whatever liquid assets we have, not for the house. If you're doing an O'Neill agreement, that kind of follows. If you want to have all the beneficiaries consent to paying estate administration costs or your fees out of exempt assets, specifically a homestead, sale of a homestead, be very specific in the O'Neill agreement that it's only to cover estate administration costs associated with the decedent's estate, including attorney's fees. Don't leave it open, because then it could open it up to all creditor claims and could have opened it up to an MA claim. I love this stuff. I love it. No two cases are alike either, so that's the great thing. If you like a good challenge, probate is a good challenge. I'll be available, by the way, after this. Mike's going to talk a little bit more about the mndocs, and then we can chat after.
Okay, I'm sorry, where are the materials?
They will be posted or available. MSBA will have them for you guys. I think on practice.
Definitely on practice law. I'll verify with Joe and Becky. I think he was just popping up a message to all my attendees about where they're going to be.
Okay.
But
you'll get them. I'll make sure you get them.
Thank you.
Okay. And out of respect for your time, we will still get you out of here by 1:30, so you needn't worry about that. I will also be happy to stay around for questions afterwards. What I want to do, though, is to show you the actual mndocs interface that Jill was talking about. Basically, mndocs is our name, and you don't need to copy down a website or anything. It'll come up pretty quick in a search, and we'll just go there, and it'll be the first thing that's up here. So don't need to worry about the URL. All of it's available in the materials that are posted. And once you create an account, and I'll probably skip through the account creation. It'll be obvious when you go there about how to do that. Right now, I'm just going to actually show you what you get once you create the account. Unfortunately, the first people to use this were our folks from our marketing department instead of us to actually create the documents and correct them along the way. So we have kind of a funny, what did I get there? Okay. But so we use their account and what's the name? Let's try practicelaw.org. There we go. Actually, it's not welcoming me, it's welcoming Mike Carlson, one of my colleagues here. So we have this, but once we get in here, this is the full set, and I never save my password for anything, anyplace. Just a little computer security tip on the side. It's always better to remember them or find a way to go through. Obviously, we have documents in a number of different areas, but today we're talking about the probate forms, and Jill had already kindly provided a couple of screenshots about what's out there, the distribution plan, the worksheets. I'll have to see if we have the equivalent of your questionnaire in advance, and if not, we'll have to create one and put that up here too, because we are open now. For a while, we did not have the ability to do these in-house. We had to contract them off to someone else to do, but we now have the ability to not only create new ones in-house, but to correct them also. So when you're using them, if you find things that aren't quite right, you find things that you think are in error, let us know. We can change them. We can fix a typo. We can put in a new paragraph, put in new logic and how they're used. But then the basics on how we use any of them are to have this answer file that Jill talked about. And actually, perhaps I should first just check so I don't tell folks stuff they already know. How many folks here have used hot docs in one form or another before, desktop or online? Okay, most of you not then. So we'll kind of go through how this works. In concept, what we have, and then the informal forms and the miscellaneous. So these are used in probate. In concept, then, basically what it is kind of a TurboTax for legal forms. So instead of going through, you may well have used fillable PDFs. The IRS puts out fillable PDFs. There you have to fill in each and every form, even if it's the same information as some other form. Someone's last name, you're going to have to fill in that last name on that number of times. With mndocs, you only fill in the person's name once. And so the benefit of that over typical cut and paste operations in Word or WordPerfect is that you can't spell the name wrong the third time around just because of a typo. You can't be using someone's nickname instead of their legal name when you get to the fourth time it appears in the document. You don't have the problems from cutting and pasting an old document for a different client that you have where suddenly you forgot, oh, this has to be a her and not a his at this point. Or you have the wrong family's grandchild's name. So you answer the questions here in the file, and let's see if, I think I may have had one. Yes, I got an application here. And this one, we'll go into it and just see how it works. What I did to do this was I did not actually enter any data on this myself. Jill sent me an answer file that she had been using to make sure that the forms worked the way they should. And so, trying to think of this. Actually, this one may have been my own. You went through another one. But basically the way it works, you can see is you enter the attorney's here. You do this once, by the way, at the outset on the attorneys. And the system keeps your firm information for any and all documents you ever create after that. And so you can enter the different attorneys on the form, change it around. If you have special drafting that you want, you can say you just got a new address. You can put in an alternative address here. You can check here to use a different law firm name, depending on what you need to do for whatever reason. But the entire set goes through a series of questions. Say, I need these documents and not these ones. And then you go through and click next. But it's all by question and answer, basically like the IRS. And just go from the screen, go through the case. I would never use an unreasonable judge as my judge's name on a sample template. So we go through here, and these issues or these names once put in can be reused in another document if you have any questions. So you'll just go through and you answer the information. You never have to fill in a blank. The program will fill in the blanks for you. And when you get in there, one of the helpful buttons appears a document preview. So you can see where you're going, you can see what's being filled in. You can verify that, okay, I don't have a blank here. In this case, I actually finished it. If, for example, I would have had a different answer at one point, then I would have had a different paragraph in here. It'll change the language depending on the answers. And then at the end, we get through the different amounts. It'll add them up for you, do the extra documents. We're going to go back to the interview, but if you ever have questions as you're filling in these forms, what answer should I put in here? Because sometimes we may not have framed the question as artfully as we should have, or given you enough clues. Go into a preview, see what information is missing, and then go back to your interview using the button up here. At the end, when you're done, you can click Finish. And this is one of the other benefits. It's going to have a couple of unanswered questions here that I didn't do because we just need to finish this up. You'll have two files that you'll get at the end. And you can use both of them. Exporting the answers, we'll save this. And the file name here, it says .anx. That lets you know it's an answer file. You can just store these entirely online if you wish. They have a very secure system. This is their business of doing nothing but that. And in fact, we just learned this morning that they have that mndocs, the engine behind mndocs, has been acquired by Abacus Next. And you may remember Abacus from the practice management programs. So we'll have to see how that shakes out, but they are experts essentially in hosting stuff. So if anything, security will probably get better. I'm going to open this just to show you what an answer file looks like. I'm not sure, we may have to, let's see, what do we have here? Notepad. It's a straight text file. Wow. Let's see if we can do it. Minus to get down below. Okay. Not sure why it's going so big, but basically, let's find a place and we'll see. Yeah, here. So we have a text value, just equal no spouse, no children, natural or adopted, etc. This is actually, you can actually edit it if you needed to on your computer, and then re-upload it if for some reason something was weird. But the main thing is that you can download this, have it saved in your file so you have a record for yourself of exactly what was used, and you can reuse it on the next document. I am going to go 2 minutes over with your permission. That's exporting the answers, and I'll show you the other thing we can do with that in a minute. When you export the document, one of the other benefits, so this one downloaded just now, 128. And if you don't like the font, just go ahead and change the font yourself. It will enable editing. You don't like the font, you think that serifs are a better choice, go ahead and change it. And so what you get at the end is not limited as a fillable PDF would be. I know we have some folks that don't like some of the real estate forms that we have, the conveyancing blanks, because those are kind of a little tiny Arial font and gets hard to read. This way you can make it easy to read for your clients. And if you have language that you prefer, even though we have language already filled in, it's been well vetted by a number of other lawyers doing this. If there's particular pet language that you think is safer, you can go in and you can edit the document yourself in the end. So that's all available. The last thing I want to show, and this relates to our point earlier about the safety of this, let's see, is that we can use another template. And so we can say, I don't want to do that part, that document. I want to go back in and let's say, I don't know if I had enough information here really for a final account, but we can just open up. So that same information, you don't need to go through the questionnaire, re-entering your client's name, re-entering the address, re-entering social security numbers. When it comes up, it will be populated with all the answers for your first document. So you can't have inconsistency between two different documents for the same client. And so those are largely the benefits to your clients ultimately, because this gets done quickly. Let's see how much of this is in the document. We'll skip the guidance. We have some of this in here as kind of a mini reminder, our own set of practice tips. But let's take a look and see, just make sure in this other template, that we've brought the information in. We have the estate, and so the different amounts. I had not entered actual values for most of these, and so really what we're saying is that any information that's shared in common between the two files is going to be the court file number, the name, matters like that. So that is a very quick explanation of how the mndocs system works. Basically, it's just a TurboTax for legal forms. We welcome you using it. Let's see if we have the subscriptions. I have to go through the registration process, but you can find all this information on our website at minbar.org with the prices. And if you have any questions, as I said, I'll be happy to